let's get started. So let's just kind of talk about what probate is in general, right? So there's two things we're going to talk about in the time that we have together. We're going to talk about probate, and we're going to talk about something else that's called estate planning. So there's a distinction between the two of them. And essentially, estate planning happens before someone passes away, right? So estate planning has to do with writing a will, writing a trust, a power of attorney, designation of healthcare surrogate. All this stuff happens while a person is alive. Probate happens after somebody has passed away. So in your all's world, probate comes into play obviously when there's real estate, right? So what probate actually is it involves a court process. It's going to involve a judge, most likely going to involve an attorney. And what we're doing is we're taking a piece of property, real estate that was owned by somebody while they were alive, and now we're going through this probate process, and at the end of it, the judge is going to say who the owner of the property is. So most likely at some point in your career, you're probably going to find a piece of property owned by a person's estate, okay? And so what an estate is, let's just say John Smith, right? So when John was alive, John owns his house, he owned his car, he owned jewelry, he owned, money, whatever he had. But now that John's passed away, we refer to him as the estate of John Smith. So that house that John had, if his children want to sell it when John owned it, they can't sell it until it goes through this probate process. So probate is really just taking someone's assets, whatever it might have been, going through the courts, and at the end of it, the judge is going to say, who gets what of it. Is that pretty clear?
Yeah.
Okay. When it comes to you all, one of the things that you all need to know is how to identify whether or not a property is going to go through probate or probate needs to be involved. So I'll give you the easiest way, and I normally have handouts, but since this is kind of a short of course, I didn't bring them with me, but the easiest way is when you look at the property appraiser's website, right? So when you look at the property appraiser's website, most likely, if the person had passed away, it's going to have their name, and then it's going to say estate of after it. Have you all seen that before on the property? Okay. So that's the easiest way that you would probably know whether or not the property has to go through probate. Now, I always get asked, how do you know if it's in probate, or when does the county, I guess I should say, when does the county put that estate of after? The truth is, I don't really know. Vital Statistics is the Florida entity that records death certificates. They told us that whenever someone passes away, they mail the death certificate to the county where they were living and owned property, and then the county will update the records. But I've seen properties where the person died 20 years ago, and it still doesn't show that estate of after it. But if you see the estate of, either that happened and the county updated. What I've seen sometimes also is, let's say daughter is living in the house, right? And so her mom passes away. Well, the property was in her mom's name, and so mom was getting the homestead exemption. And so everyone probably knows what homestead is, except for maybe our new realtor. Do we know that? Okay, all right. So
He knows.
you passed the test, right? So now the daughter wants to get that homestead exemption, right? She wants to pay less taxes on her property. So she'll go to the county and say, look, my mom passed away. It's my house now. I want to get the homestead exemption. And then the county's going to say, no, now that we know that your mom's passed, you lose the homestead exemption. And, so now she's got to go through the process. So I never tell people, don't go tell the county, because that's homestead fraud. But know that if you go update that, if you go tell them, they're most likely going to update who the owner is, and you'll lose the homestead exemption. So that might be a way that you can tell. If you see that estate of, that's the easiest way to know that probate might be necessary. So if you see that, or one example that I've seen, a case we had a little while ago, was mom and dad owned a property together. Okay, this was an investment property that they had. It was owned, I believe the names, Maida was the daughter and Jesus was the father. And they owned it in a way what's called, this is kind of a legal term, but tenants in common, which just basically means Jesus owned 50%, Maida owned 50%, right? So when Jesus died, Maida didn't automatically get the 50%.
No right of survivorship.
Right, no right of survivorship. She thought she got it because she's the only daughter. They own the property together. So what happened is she got a realtor, she lists the property, she goes to closing like 4 months later, and then what do they say?
Forget it.
You gotta go to probate, right? And so she was obviously upset. So if you see joint owners, and again, your job is not necessarily to interpret title, that's why you have the title company, that's why you have your title attorney kind of reviewing everything. But just because people own a piece of property together, when one of them passes, it doesn't automatically mean that the owner, that the surviving person gets the entire property. I'll pause for a second, I see some blank faces. Does that?
Only if you have right of survivorship.
Right, so how
Or
could,
if they're married.
right, so how could probate be avoided, right? So that's a big question is, obviously, there's an expense with probate. I'll tell you all right now, length of time. So how long does probate take? Generally, it depends on when the person passed away. There's two scenarios. So if the person died recently, so within 2 years, it's probably gonna take about 6 to 7 months, okay? If they died later, if they died more than 2 years ago, it's probably gonna take about 3 to 4 months, okay? And those are just, things can change. We've got crazy stories where people fighting and all of that. It can make it a little bit longer. But that's generally, the time frame that it's gonna take. So
Less than what?
if they've died recently, so within 2 years, it's gonna take about 6 to 7 months. If they died more than 2 years, it's probably gonna take about 3 to 4 months on average. And the reason for the difference, just real quick, is in Florida we have what's called a creditor period. So if someone, and I know I'm getting kind of technical here, but if someone passed away, right, within 2 years, and let's say they owed money to Visa, they owed money to Home Depot credit card, they owed money to Baptist Health, to Palmetto Hospital, whatever, those creditors have a time period within 2 years that they can come and say that, hey, we're owed money. John owed us money.
They have to
Even
file.
if it's a homestead?
They can still say that they're owed money, but they do not get to get anything from the homestead property. So the homestead property is completely exempt from creditors,
Yeah.
except for the lender can foreclose, the association can foreclose, the
IRS.
property taxes,
IRS.
IRS, right. You don't mess with them, they'll take everything.
Yeah.
Yeah,
Okay.
so,
They
so,
have blood, huh?
yeah, right, if they could, they probably would, right. So that's the difference, is that if the person died more than 2 years ago, then they're kind of, it's called limitation, statute of where they can't make any claim on anything. But if they died within 2 years, they can still make that claim. Go ahead.
What happens if someone has a homestead, obviously, but then they have several investment properties?
Sure.
Those creditors can lien those investment
Yeah,
properties.
Absolutely.
Yeah.
Because what
Absolutely.
we've seen from a title end is where we have to wait for that order authorizing the sale.
Sure.
And many times, that order comes with specific instructions that we need to follow on the disbursement of funds.
Right.
And many times it goes into a depository,
Mhm.
from what I've seen.
Yep.
And it's because we've seen that creditors are there,
Yeah.
being listed.
Yeah, so that's a great point. So the homestead property, again, completely exempt. The creditors can't go after the property, can't put a lien on the property, and once the property is sold, they can't get the money back that the buyer, or that the seller is going to receive, right? They can't.
Okay.
However, if there's an investment property, or let's say someone passed away and had $50,000 in a Chase checking account, they might be able to, well, they can go after that. Now, we, the attorney, we fight them and we can reduce or get them completely stricken if necessary. But if there's an investment property, what might happen, it depends on the seller, right? The people inheriting it, they may wanna keep the property, so they might just pay the creditor out of pocket because they wanna keep the property. Or if they don't have the funds to do that, let's say Baptist is owed $10,000, right? So when we sell the property, there's some things that we, the attorney, have to do so that they get paid the $10,000 out of the sale.
What happens if the state, part of their state is properties abroad, let's say in Puerto Rico,
Sure.
or what happens in that case? How it works? It works with their laws of.
It works with the
that?
laws there, right? Yeah, I can't do anything to affect the laws there,
cannot,
right?
okay.
Yeah, and it's kind of works the same way here in this, we're working on one right now where, the gentleman passed away, had a property, in Hollywood, but, he had a will from Canada. And the will said some stuff that doesn't work here, so we can't really go by what the wills say. And same, I've had wills from Colombia and from different places,
Right, right.
and so we still have to work within Florida laws. And equally, the wills and the trust that we draft here might not work in other states or in other countries.
Right.
Okay, so we talked a little bit about how to identify properties. Now, how to avoid it, right? So how can we avoid going through that 6 to 7 month process, 3 to 4 month process? Obviously, it costs money and all of that, which if we can avoid it, that would be great. So there's a couple ways. One of the easiest ways is by how you deed the property. So how the property is actually owned. So you all had mentioned joint tenants with right of survivorship. So that's a very easy way where it's a specific way where the deed needs to say joint tenants with right of survivorship. And Clarita, chime in because this is your area that you know very well.
I know.
But if you have that designation on there and done properly, this is not a do-it-yourself type of thing. Then when one of the owners of the property passes away, it automatically goes to the other person, and you're not going to have to go through the probate process. Okay. Same with spouses, right? So generally, if you've got a husband and wife on title together, and it's probably not going to say tenants with right of survivorship. It's going to say as husband and wife, a married couple. Most likely is mostly what it's going to say. If husband passes away, the wife automatically becomes the owner, and she doesn't need to do a probate for them. And similarly, if the husband she passes away, he doesn't need to do a probate for them either.
But then when the wife passes away, they do probate for both?
No,
Or just
you
the
would just do
husband?
the one who passed away most recently.
Okay.
Right. So when husband passed away, no probate was needed. It automatically became the wife, and so now wife is 100% owner. When she passes, if they don't do anything, probate would be needed for her. Yeah.
Okay, I have property, I have 3 kids.
Sure.
They all have, right of survivorship. But a friend of mine that she's an attorney says to me, yeah, but you know what happened? If they got an accident or something, they can go to your property. So.
It's possible. Yeah, it's possible. Yeah. So that's just. But this is just. I'm just talking about one way to asset protection is a whole nother thing, which I'll talk a little bit about maybe if we have time. But joint tenants with right of survivorship is a way to avoid the probate.
If the property is on,
But,
excuse me,
No, go ahead.
if the property is in the name of both husband and wife, on a fee simple, it's the same as, they
Yeah.
both own it at the
Yep.
same time. So if
Correct.
one dies, the other one is automatically,
right.
Correct.
there's nothing, there's no probate.
No probate
No,
necessary.
no.
Yeah, I just wanted something that came to mind, the married couple situation, that's tenancy by the entirety.
Yep.
That's how we refer to it, which is equivalent to joint tenancy
Sure.
with rights of survivorship on a married couple. That's why we don't
Yep.
have that from a title standpoint. But let's say that I am Clarita Rosa, a married woman. I own this property. I pass. My husband is not on title.
Mm-hmm.
He has to probate.
Yeah.
Because he's not on title, and just because he's my husband, and I'm a married woman,
Mhm.
and his name wasn't on title, there is a probate.
And that's a good and let me ask you this is for me, because I've seen it where sometimes the title company will allow you to do like an affidavit of continuous, I think we were doing something like that.
We do an affidavit of continuous marriage, when, I wanted one of the closers to come,
Yeah.
because they
Sure.
know more than I do.
Yeah, sure, that's fine.
Laura.
That's fine.
Yeah, come, join us, please. The continuous marriage affidavit is usually done, which we see our underwriting counsels requested on a title commitment,
Mhm.
when it's Clarita Rosa and her husband, okay, he died, let's
Right.
kill him first, and then I am.
We always go first anyways.
And I'm gonna sell my property,
Yeah.
and, now, I need a death certificate for
Mhm.
my husband, I need a continuous marriage affidavit stating that I've been continuously married from the time that I own that property. Because the moment that there is an interruption, I got divorced and then I remarried
Oh, yeah.
my Prince
Yeah,
Charming,
that's sure, yeah.
that tenancy by the entirety broke,
Right.
and it will never come back, even
Yeah.
though I remarried.
And if there's any
So,
judgment.
And then if
things like
there's
that.
any judgments, but, for
Yeah.
probate purposes, let's say I was continuously married, happily ever after, he passes, I'm ready now to move on in life, and I'm selling, I need a death certificate, a continuous marriage affidavit, and what else is needed?
For us?
For
Yeah,
us, that's it, right?
Yeah,
Yeah,
for us, that's it.
but if there was an interruption and he passed, we have to go to probate.
Yeah.
Because there was an interruption.
Yeah, and so the other issue kind of along those lines, and I'd be interested to hear your thoughts on it, is if husband or wife owned a property before they got married, right? So so husband owns a property, wife owns a property, and it's just in their name alone. They weren't a married couple at that time, and then they get married, but maybe this is an investment property, right, or a second property.
Yeah.
I think probably you'd have to do a probate for that.
Exactly, you
Right.
do.
Yeah, so
The-
you,
The only one that's covered would be like your homestead, any
Right.
other thing, because if you have heirs or things like that, if he was married before and he has other kids, so yes, you
Yeah.
do need to have probate.
yeah. So, if any of you all second, third marriages and you've got assets from other things, before the marriage, you might want to retitle them if you want that spouse to get them. without going through the probate process. Right.
Which
Yeah.
is, it's a little bit important, especially for realtors when they're taking a listing, to find out, it's not to be nosy, but
Yeah.
to find out, because then guess what happens? You think everything is fine and dandy, oh, I'm remarried now, and you have no idea. But then when you come to title, and then guess what? You gotta do probate, and probate takes a while, so your closing
How long does it take?
stop.
3 to 7 months.
So all of a sudden, you think you're having a closing.
7 months.
All of a sudden, yeah, you think you're having a closing within a month, and you're like, oh, good, I'm
Yeah.
getting my commission, I can go shopping, and all of a sudden, they're like, we gotta go to probate, because you didn't ask those questions, because number one, either you were embarrassed, like, I don't wanna pry in people's business, but sometimes you have to, because at the same time, you're helping your client. Because now he's gonna say, oh, but so it's very important to
Yeah.
ask
Yeah.
questions when you're getting a listing.
Yep.
Yeah, that's information that you need.
Yeah.
Yeah. Okay.
Okay?
Thank you. Perfect.
No,
Maybe
that's-
be on standby just in case.
Just reach out.
Right.
Just reach out.
So that's another way. So we talked about the joint tenants with the right of survivorship, the tenants in the entirety, husband and wife, how to avoid it. And then there's two other types of deeds that can be done as well. One of them is called a regular life estate deed, and then one of them is called an enhanced life estate deed, right? So the life estate deed basically just says when you put the other person on title, right? So when I pass away, I want my daughter to receive the property. And she's already on title right then and there. When I pass away, she gets the property. It's not gonna have to go through probate. The concern with that is I can't sell the property without her permission. She's got to agree to it. And let's say I don't like her husband and I don't want her to get the property, or we have a falling out. Now I'm kind of stuck with her being on title, right? I can't change it. I can't, without her being on there. So that works in some instances. It avoids probate, but you got to really trust that person and make sure you like them, for the remainder of your
So
life.
you said regular
That's hard.
life estate and-
Life estate deed. Yes.
Life estate will, and the other one is?
Enhanced.
Enhanced. Yeah.
The enhanced life estate, the Lady Bird deed, with a life estate remainderment, however you refer to it, or the law refers to it. What happens, because I've seen it a lot from attorneys out in Palm Beach, that they have a clause that says that the tenant, because now if I have a life estate and I leave everything to my 3 children, I go ahead and, while I'm still alive, I'm a tenant in my own property, right? So I've seen it where there's wordings stating that I have the power to convey,
Yeah.
to mortgage, like it gives you that power. Now, to a lot of times lenders do not like that. Some lenders will go ahead and say, yes, go ahead, you can go ahead and mortgage, refinance, do whatever you wanna do. Or other lenders I've seen, even though they have that wording, they have the whole caravan join in on the mortgage with me, not the note, but on the mortgage.
Yeah.
So have you seen that, in your experience with this?
So we're talking two different things. So the regular life estate deed is not gonna have that language that gives them the power to do that generally. It might have that. The other one, the enhanced life estate deed, what we call a Lady Bird deed, that's what it's called. Would generally, and I'll touch on that in just a second, but the difference is the Lady Bird deed, I can still put, in that example, my daughter on title, but I don't need her permission to take it off. I don't need her to take her off. I don't need her permission to sell the property and all of that. I can do it, it's still my property, but when I pass away, if she's still on there, she automatically gets it. So there's a
That's
difference.
like irrevocable?
It's called a Lady Bird
Lady
deed,
Bird
yeah.
deed.
So there's the regular life estate deed, and then there's the Lady Bird deed. Yeah, enhanced life estate. So what Clarita is saying is that a lender may have some sort of issue giving you that much authority with that type of deed because they don't always like that. My suggestion, before you do any sort of title change whatsoever, is speak with your lender first, right? To make sure that you're not going to trigger, you know, some sort of due on sale clause where everything, all the mortgage becomes due and owing. Right, you might need approval for it. So maybe I haven't seen it just because it hasn't trickled to me at that point, but I haven't really seen, a lender wanting to put all of the remainder people on.
Yeah, well, not
Yeah.
after the refi, but I've seen it when someone applies for a
Gotcha,
refi.
okay.
And then I've seen that they've required to
Okay.
have the remainder join it.
Gotcha,
you know.
okay.
But after the refi, I mean,
Yeah.
yes, you have to be cautious, I agree, because of that paragraph 17,
Right.
the due on sale clause, because you're triggering, you know, changing the title. But yeah,
Yeah.
I mean,
Okay.
What about, like I have a situation with my daddy has a reverse mortgage, and I'm actually gonna have him sign this ladybird clause tomorrow.
Mm-hmm.
And so technically, in all reverse mortgages, HUD owns them. Is that going to trigger something with HUD?
I don't know the answer to that. What I will say with reverse mortgage, I mean, they're tricky.
I know, they're like the
They're
devil.
very tricky,
Yeah.
and so
Different.
I don't wanna give you a specific advice, cause I don't know, frankly. I'll just give you an example generally when it comes to reverse mortgage, what happens in when someone passes away, right? So the reverse mortgage, their remedy to get paid back the money that your father was receiving is to foreclose.
That's right.
So they generally have some sort of year buyback, you know, clause where they'll let you get it. But it might not be worth it, right? Like depending on when he took out and that's what happens in a lot of the probates I see. I'll get a potential client and they'll call me, and after we go through everything, you know, they took out $200,000 and the house is only worth $150 or something like that. So it doesn't make sense. So you probably want to find out where he's at in that mortgage because you may not want the property.
Oh, I know, yeah,
Yeah.
it's,
So I would just
the interest just,
yeah, and so you just let it go to foreclosure or deed it back to them, you know,
yeah,
whatever
his
that option is.
the loan amount and what the interest is now is like double or
Right.
more. And it's like,
Yeah.
never, ever get a reverse mortgage.
So to kind of bring us back, you know, to the ways to avoid probate, like I said, there's a couple, just generally speaking, you can change the way, you can avoid probate by deeding the property, having the title written in a certain way. So that's a very easy, cost-effective way to do that, to avoid probate. The other way is by having a trust, okay? And so trusts are becoming more and more popular. People are looking at them, but they're definitely not a do-it-yourself type thing, right? So they're definitely, I would say, not a do-it-yourself type thing. I'll talk about trust first. So a trust, generally what it is it's a legal document saying who's gonna get your stuff after you pass away, right? So it's, you know, we draft a document saying, I want my wife to receive this, my son to receive this, et cetera, et cetera. And so if done properly, we can avoid probate by doing the trust. But here's the step that a lot of people miss. It's not enough just to have the legal document that says, my son gets my property when I pass away. He can't go to the county, the property appraiser and say, look, my dad left me the property, here's the trust that says it's mine. The county is going to say, sorry, you're gonna have to go through probate, get an attorney and do the probate. How he could avoid that is what needs to happen is first, let's say I own 123 Main Street, right? So 123 Main Street is in my name only, Justin Stivers, individual owner of 123 Main Street. But I wanna do a trust and I wanna make sure that my son gets the property without going through probate after I pass away. I would create the trust, that's step number one. Step number two is I need to deed the property from myself, Justin Stivers individually, to the Justin Stivers Trust and make the Justin Stivers Trust the owner of the property and record that deed. Probably have to record a certificate of trust with the with the property appraiser as well, so that when you go to the property appraiser, you see that the owner of 123 Main Street is the Justin Stivers Trust, dated, whenever I signed it,
But
right?
you don't lose the homestead
No.
because of.
You need to put
doing
certain
that.
language in the trust and on the deed, but you're not gonna lose the homestead exemption.
Okay,
Generally, one thing to be cautious of with trust is homestead, you're generally okay to do a trust even if there's a mortgage. Investment properties, probably not okay to put the property, or a secondary property
On a trust?
on a trust, yeah.
LLC.
Yeah. Again, you wanna,
Why not?
why is that?
that's generally a clause that they'll have in the mortgage itself. Again,
That's if it's a financed.
If it's paid
Right.
off.
if it's paid off, you're not gonna have,
then
if it's paid off, you're not gonna have any issue.
Okay.
Right, but if there's a lender, and this is one of the areas where I say, let's speak with the lender before we just start changing title. For homestead property, and for trusts in general, it's not gonna trigger the change of ownership clause or anything like that.
The lender may not accept it.
Right, but that's something that we wanna discuss before we just start changing it. I've just seen, and I know that there's issues, on secondary property. I don't know if Clarita, if you've seen that or have any, yeah.
We have seen that, and there's also, lenders are very particular about revocable trust and the
Yeah.
irrevocable trust.
And I'll touch on that in a second, yeah. But if done properly, so remember, this is just important because I see a lot of people and they'll do the trust document, which is great, but they don't actually change the title. So if you don't change the title and make the owner of the property the trust, it's worthless, essentially. I'll talk a little bit more about trusts since we're on the topic. Trusts are, obviously in your world, they're great for real estate to avoid the probate process or probate proceeding, but they might be good for other reasons. Where they come in handy is people with minor children who have younger children. If you don't have to have when people think of trust, they think of people who have millions and millions of dollars, offshore accounts, all that. Maybe some might have that. But you might have, even if you've got $100,000, $200,000 or something, and you want that money to be distributed in a certain way, and you want there to be some sort of oversight to someone see how it gets managed, then a trust might make sense. But like I said, for young kids, they're very important. Just thinking of a client that hired us yesterday to do one. They've got 2 minor children. All the parents reside in different states, and so they want to name who would be the guardian if the 2 parents were to pass away. They want the kid to go to a certain type of school and all of that, so that's when we would use a trust. Okay? The difference between a revocable trust and an irrevocable trust. Revocable just basically means you can change it, right? So while you're alive, you can change the trust. Irrevocable means you can't change it. All right? A trust automatically becomes irrevocable when someone passes away. So I create a revocable trust while I'm alive. When I pass away, it becomes irrevocable. Nobody can change it. Irrevocable trust won't spend much time on just because when we generally use them, they're for somebody who, let's say, is a little bit older and they've got some assets, they've got not necessarily substantial money, but they foresee themselves having to go on Medicaid at some point, right? And so an irrevocable trust is a way to move all of your assets, put them into an irrevocable trust, so that when you're applying for Medicaid, they don't see those assets as belonging to you, and you can still qualify for Medicaid. So that's a tool that is used. There's other reasons, but that's one of the more common ones. Most people, though, are going to do a revocable trust. Yeah.
Yeah, and I think that if they have that mindset, I think they have to do it like 5 years.
Oh yeah, there's a
There's a
a
time
look back period.
limitation
Yeah.
that they just can't, let's say you have an elderly parent, they become ill.
Yeah.
You have to transfer them into a nursing home, which we all know is very costly. You just can't create that
Yeah.
irrevocable trust right there and then and think that that's going to go into effect. It won't.
Yeah.
In my
No.
opinion, I don't think so.
Yep, you have to have, I believe the look back period is 5 years. So if you did the trust, today and you go tomorrow, that's not gonna work. You had to have been done several years in advance.
That's the irrevocable.
Oh, really?
That's the irrevocable, yeah, yeah. So you have to plan in advance, at least 5 years in advance. to do it.
Wow.
Yeah, because they know what you're doing, right? They know that you're trying to get rid of all of your assets and transfer just to qualify. We'll pause on trust right now. The one other thing, so those are all ways to avoid probate, right? So those are probably the easiest ways to avoid probate. And we're really just talking about real estate. There's just, if you want some useful tips, real estate's probably the most common thing that we see going through probate, but there's other assets like money in a checking account, money maybe in a life insurance policy, maybe stocks accounts, that sort of thing. And what happens is the person whose account it is didn't name a beneficiary. Or maybe they named a beneficiary. This is a life insurance policy you bought 20, 30 years ago, and maybe you named your wife or your husband and they've passed away, and so now there's no beneficiary. You still have that policy, and assumedly it would go to your children, but if you haven't named a beneficiary, they're gonna have to go through the probate process to get that money. So the best, if you all have, let's say you have a checking and savings account, right? So you probably have a checking and savings account maybe with your spouse. What you can do is, let's say you want to leave, if you're joint owners, your husband can get it when you pass away, your wife can get it when you pass away, no issues. But when you both pass away, Chase, Bank of America, Wells, whoever is going to freeze that account until a probate is open. So what you can do is you can name what's called payable on death or transferable on death, where it's kind of like a beneficiary. So let's say I'm married, and I want my children to receive that money after we both pass away, but I don't want them dipping into those funds right now, right? So I can just go to Bank of America and say, hey, listen, I want to do what's called a payable on death. They're the same thing, but POD, TOD. And I say, I want to put my son on the account when we both pass away. That's fine. They'll do that for you at the bank. And then when you pass, the child or whoever you name on there can go get the money, and they're not going to have to go through probate.
They won't be able to get the money before. Right?
No, not before. Not before. Yeah, that's very important. Very important. Don't make them a joint account owner. Yeah.
Minimum access
It
to
needs to be clarified.
Yeah. So we know how your kids are. Now we know.
No, it's nothing to that, it's just,
Yeah.
I know how the bank thinks.
Yeah.
I used to be a banker.
Yeah.
And,
So,
and
I know how they think.
I did that with my dad, and the woman was there like, are you
Mhm.
sure?
Right?
You wanna put your daughter
Yeah.
on? And he's like, yeah.
Yeah, joint account, if you put them on the account now, they have access to the funds right now. So I never suggest that to any of my clients,
I do.
ever,
Except
really.
honest stars.
Except for
like
honest
me.
stars.
I only have one daughter, she gets
I do
everything,
half
she's
like
seeing everything, all my accounts,
My
everything.
2 daughters.
Yeah.
She don't have to go
Yeah,
through
so you
that.
can name, so if you have children and you want them to get it, but you don't want them, the POD, the TOD is a great option. The other option, so those are banking checking accounts. If you have stock accounts, if you have investment accounts, if you have a 401k, an IRA, Roth IRA, anything like that, double check, make sure that you have beneficiaries on them, make sure you have secondary beneficiaries on them. And this is a little advanced, but one thing, thing you can do with the trust is if you have a trust, you can name the trust as the beneficiary, so that again, the trust says what happens with that money, and the bank, when you pass, will issue a money to the trust, and you avoid probate. So that's another thing you can do. Last will and testament, right? So everyone's probably heard of a will. So wills are similar to a trust in the sense that it says who's going to get your stuff after you pass away, right? So you're going to say, I leave my house to this person, my jewelry to this person, et cetera, et cetera. The difference between a will and a trust is that, and if you look on my business card, on the top line, it says, did you know that having a will does not avoid probate?
Right.
So that's the answer. So a will does not avoid probate. And it's a big misconception is just by having having a piece of paper. If you've got a will, and let's say my dad passes away, and in the will he says, I leave everything to my son Justin, and the house. And I go to the county, again, we know the county's gonna say, hire a probate attorney. It's not enough that the will said that I get it. I'm still gonna have to go to court, and I'm gonna have to show that this is a valid will. And the reason is because there are, requirements of how to make a valid will, and people can have 2 wills. And so I've got, just a quick story right now, I've got a case where a lady passed away. She had a will that was left to my client. I think it was signed in the early 90s and she's the granddaughter, and it says that my client gets the house. Okay, great. But she did a will in like 15 years later that left the house to the son. Okay, that happens sometimes, right? Like, so you do a will, someone in here probably has a will that they did 10, 15 years ago, and maybe you need to do an update. That happens all the time, and the newer will supersedes the old will.
Right.
But the problem is, grandma had Alzheimer's when she did that will. So we fought them on that, and it was a sad story, and we ultimately won, and the judge, invalidated that will. But that's why just having a will is not enough, because there might be a second will out there that you don't know about, which is why you have to go to court and do all of that. So having a will will not avoid probate, right? So people do wills. They're not bad to have. They're fine documents to have. It just depends why you're doing it, right? So wills are generally cheaper than doing a trust, which is maybe why people do it. Wills you can go to online or fill in the form, and they're fine. They probably would be fine, and so you save $1,000 or $2,000, whatever the cost might be. But you do that knowing that whoever you're leaving the property to, or whatever you're leaving it to, is probably going to spend $6,000 or $7,000 and 7 or 8 months in order to get it. And I've had clients say to me, "Well, my son's getting it. Let him deal with that." Okay, fine. That's valid. So, anyways, very important that you know that wills don't avoid probate. When it comes to you all, of who you're working with as the realtor, right? So this is maybe the most important thing is you all. If let's say we're talking about trying to list a property, okay, and we've determined that the owner has passed away. So the property is owned by the estate of John Smith, and now John's daughter, Vanessa, wants to sell the property. Well, she's going to have to go through the probate process. However, you need to make sure that she is going to be what's called the personal representative. All right? So some states use the word executor. For example, New York uses the term executor. We use the term personal representative. The personal representative is the person authorized to sign the listing agreement. It's the person authorized to sign the closing documents. It's the only person who has the authority to sell the property. Okay? So a lot of times what happens is, I've seen this, and we were talking about this earlier, where let's say in that example that John died, no surviving spouse, his only daughter is Vanessa. All right? And so Vanessa comes to you, and she says, "Look, I want to sell this property. It was my dad's. I don't have any other siblings." And you're like, "Great, let's go list the property." You go list the property, but she's not the personal representative. And let's say John maybe had a will and named somebody else as the personal representative, which happens sometimes, or left the property to somebody else. Well, now, even before, but now Vanessa has no right to that property. She can't sell it. She can't sign any closing statements. The seller's going to be angry. Title's going to tell you, you got to go through probate. You wasted all this time. So the personal representative has to be appointed by the court. Even if somebody has a will, and most wills are going to say, "I name Justin as the personal representative." Most wills are going to say who they want to be the personal representative. But if you have a client that comes to you and says, "Look, here's the will. My dad named me the personal representative," you're not good to go list the property. Because what happens if that will was the son's in that example that I just gave you, and I have another will, and now my will names somebody else as the personal representative? You didn't have any authority. You have to wait until the court signs this document, which doesn't matter, but it's called Order Appointing Personal Representative. Until that judge signs that piece of paper, you can't list, you have nothing. You can't list the property, you can't do anything.
So regardless of what the will says.
Regardless of what the will says, it has to go through probate. Because again, you could have two wills, or I've had situations where the will was not executed properly, so the judge said it's not a valid will, and now that person's not the personal representative. And yeah. Any other questions on that? But that's very important. That's where I see a lot of people making mistakes, is because you're like, "Oh great, I see that commission check. I want to get this listing." Wait until you have that piece of paper from the judge.
Why the will would not be done properly?
Right. So it's pretty easy to make a will in Florida. There's not it needs to be signed at the bottom, and it needs to be witnessed by 2 people. And all 3 people, the person making the will and the 2 witnesses, need to sign at the same time and watch each other sign. that's really the only requirement. It doesn't have to be notarized, but for a variety of reasons, it's good to have certain language and have it notarized.
Just in case.
Just in case, well, and it makes my job easier when I go to prove the will. But in that case, the example I gave you, we might challenge the person's mental capacity to sell it or to sign it, or maybe she was coerced, legal term, but maybe someone was like saying, "Hey, mom, sign this, sign this, sign this," and mom doesn't really know what she's doing. So those are some reasons that the will might not be valid.
So what would you say during the listing presentation that I'm gonna refer you to my attorney and let's just make sure everything is good to go before the house is put on the market? So here's his number, make sure our ducks
Sure.
are lined
Yeah.
up, and then we can list it.
So that's a good question. So you might be in that position. You might be able to, you might find that listing before it comes to an attorney, right? And so then you could say, "I hear what you're saying. I think we need to speak to an attorney before we list the property," right? Sometimes, probably more often, it comes to us first, and then we send it out, and I say, but it happens, definitely happens, both ways. Now, what I generally, so here's, and Clarita, I'll defer to you and see what she thinks. She might disagree with me. But what I've seen realtors do before is, let's say that you find somebody and the property, it's gotta go through probate, right? But the process hasn't been started. We don't know, we think that they're gonna be the personal representative, but again, no probate's been open and the judge hasn't signed that piece of paper yet. Just to give you an idea, from the date that the client comes to me, we sign the paperwork and we get the case filed, it takes about 30 days to have the judge sign the order to get appointed personal. So it's about a 30-day process to have the personal representative. I'm gonna say PR, that's what we call them, and I'm like exhausted by saying personal representative. So PR, so it takes about 30 days to get the PR appointed. But let's say January 1st, you find that client, and we know it's probably not gonna be until January 31st before the PR is appointed. Well, you may not want to tell that client, "Come back to me in 30 days when you're appointed as the PR," because, how many different, well, there's only like a couple different brokerages, but there's a lot of brokerages that or a lot of realtors, they might just go find somebody else. What I have seen realtors do, and have not seen too much of an issue, is they sign the listing agreement as the proposed personal representative. They're not yet the personal representative, okay? So in theory, this contract may not be entirely valid, right? They might be able to go to somebody else. But it at least kind of gets them thinking that this is my realtor, I'm working with them, sort of thing. It's more of a mental thing. Once we get the PR actually appointed, I would update that and say John Smith or whoever as the personal
But
representative.
we should not list it in the
But you
MLS.
100% don't list it.
Don't
100% don't list it until you get the actual order appointing
Okay.
because again, what happens if I even think that this is going to be the personal representative? And I had a case recently where I had a son show up, and I didn't even know there was a son. Right? The daughters told me there were only 3 daughters, and the son shows up to court. Fortunately, it worked out, but so I might not even know. I did my due diligence. I researched. But there might be another reason why it's not why they're not PR. So I say, I've seen it be okay. You sign the listing agreement because you don't want to wait 30 days, but have them sign it as the proposed personal representative. Once I or the attorney gets the actual documents from the court saying that they're the personal representative, update the listing agreement, and then you can go list and sell it. But 100% don't list, don't market, don't go put door hangers or signs in the yard until you get that order appointing personal representative. You okay? Okay. Yeah. So that's what I've seen, but that's probably one of the biggest takeaways. Don't go list until you get that order from the PR. Yeah.
And once they finally list, and then they do go under contract, you're still working on the probate, that's not a problem.
Right.
We do our due diligence,
Right.
we do our title examination, our Schedule B1 will show all those requirements. And then we work very closely with Justin
Yeah.
or the probate attorney that, the seller has chosen, and we get it closed. But there is a process, and we all know
Yeah.
that it will take 3-6 months
Yeah.
to get it all resolved.
Yeah, what I always, this is not, like, from your all's perspective, there's not a whole lot that you all do differently, other than signing it. Anytime you sign the contract or everything, it's gotta be as the personal representative. It's not the person, it's not that person individually, it's them as the personal representative. So apart from that, there's not a whole lot different that you all have to do. The difference in this process is that there's probably gonna be some court intervention, which you guys don't really have to deal with. There might be a little bit more family dynamics because someone's passed away, which you guys may have to deal with, but a lot of times that's me dealing with that. The biggest thing though is probably just the length of time. So if you've got a buyer on either side, you know, you're representing them or you're in the seller and you're dealing with the buyer's realtor, if they say, you know, I gotta get in that house in 30 days, I would caution you to promise that, because things come up, and again, I've gotta get court dates, and so it does take a little bit more of a process. So that's why you wanna just make sure you're speaking with the attorney who's doing it and say, listen, what's a realistic time frame? But I always err on the side of caution and tell the buyer, listen, this is not, if you're looking for a quick buy, this might not be, it could be, but it's probably not. Yeah. One more thing I was just thinking about, wills. So, because this actually came up yesterday, actually from a realtor. Her stepmom had recently passed away, and basically it was like her mom, right? But she was never biologically adopted, or never adopted and not biologically related to her. But the stepmom, we don't know if she had a will, and so the potential client wants to know how we can find out. And the truth is, wills are not recorded. So wills are generally not recorded with the court. I could, draft this right now, have you all sign it, and then I could give it to Clarita, she keeps it here. My family's gonna have no clue about it,
But
right?
there is a time to,
No, there's no time limit. I mean, you could, if you find it, in practice it might be difficult if it's really long because the assets have been sold and everything, right? But if it's, there's not like a will.com that I can go to and search for it. When we draft a will for somebody, I keep electronic copies and I give the original back to the client, okay?
So what happened in that case, if they can't find out if they left
To be determined, because it was yesterday. So I told her, I go, listen, the problem in that specific case is because she's a stepdaughter, she has no rights to the property anyways. Okay, so I said, unless you find a will, someone else is gonna get that property. Yeah, and so people think that the will gets recorded with the court. It really doesn't. It's, again, maybe in a lot older wills, I've seen them like in the 80s and 90s, where maybe the attorney kept the original. So if you can find the attorney and he or she's still alive and still practicing, the same phone number and all of that, which I've had wills, very old wills, and we found them, but like in this case, she doesn't know. She has no clue who the attorney is, so it's difficult. So if one other useful bit of information is, don't put them in a safety deposit box, because it makes it more difficult to get into it. Right, we can't, there is a legal way, but then there's a cost and all of that to do it. So I normally say, let one or two people know that you have it, keep it in, a fireproof safe or something, maybe that you have at the house, and let people know that you have it, right?
In this case, the
They're
fire is,
obsolete.
They're kind of obsolete. I think that they're so easy, and if you're not using an attorney, and even some attorneys, will do them super cheap, that you feel like you've done what you needed to do, but in practice, they don't really do a
so
whole
the
lot.
trust is recorded with the court. That's my question.
No, the trusts are generally not recorded
not?
either. The trusts are
No.
generally, but
The trust on the deed.
on the deed, right.
That's
You're
not-
gonna, on the
That's
deed, it's gonna be
recorded.
recorded, and if you name the beneficiary, in one of your accounts, they're gonna have records of the trust as well.
Okay.
So they're more findable. They're more findable than,
I have another question.
Okay.
If the property is owned by an offshore company, the person passes, and that corporation offshore is expired,
Yeah.
what happens?
I have to, so let me answer it,
You
and
know, they
let me
have
sort of
a-
like answer that question.
Uh-huh.
Just one more quick little thing about, I'm gonna answer that, and then I'm gonna shift topics just to give you a rundown of a couple of other things I
Okay.
wanted to touch on, cause I know we're running low on time. So to that point, here's one thing I see a lot of. LLCs, right? So a lot of people here in South Florida work with investors or foreign investors who have companies, whatever, and so they purchase the property in the name of an LLC.
Yeah.
Fine, that makes sense, because for tax purposes, for liability purposes, it makes sense. However, you have a lot of people buying properties and they do the LLC themselves, right? Again, super easy, go on sunbiz.com, it's like $100 or less or whatever, you create an LLC, you do the registration, annual registration, and it's easy. But if I create an LLC and I am the sole member of the LLC, what happens when I die? Well, someone's gonna have to probate that property. And 90% of investors do not do an operating agreement for the LLC, right? So they could easily do an LLC and say in the operating agreement, if I pass away, I want my shares to be purchased by, or I want the LLC to be in continuing operation by my spouse or whoever. So, and another thing you can do is you can put the LLC in the trust and make the trust own the LLC. But I have been seeing more and more of this where, because LLCs, I think, started becoming a thing in the early 90s here in Florida, and every company or everybody tells foreign investors to buy, purchase a property in an LLC, which is fine, that's great. But again, when the owner of that LLC passes away, that family back in Venezuela or Argentina, wherever, is going to probably have to do a probate for the owner of that property.
We just wanna add something in, and I'm gonna let Laura speak a little bit about that, because we do need an operating agreement.
Yeah.
And, when offshore properties, they're dissolved or something has happened, there's a specific wording that has to be, disclosed. I'll let Laura take the floor.
The unwind of the liquidations of the assets. But I just came in at the end, so I'm not too familiar with what you guys talking about, but just to recap, I guess we're talking about LLCs.
Yep.
You're absolutely right. When we see a lot of LLCs, 99.9% they don't have operating
Yep.
agreements. And it's such a headache for us as title people, and they don't understand how difficult it is, because you could show as a manager, but it doesn't mean that the LLC is being by the managers. It could be the members that make decisions,
Right.
and maybe they're not the members who appears as managers. So it becomes, and then that could be a title issue later on. So we really need to dig, and so it's very important. But you're absolutely right. If the LLC is dissolved, and the manager, let's say, or the member is deceased, then that part will have to go to probate.
Yeah.
But when it comes back to the actual deed, we could deed out as long as we had the wording that
Yeah.
it just says, unwind and liquidate assets and things like that. Doesn't
Yeah.
mean that it has to be, reinstated. But, so it's two different things. If they're still alive, we could do it with the
Yeah.
wording. If they're deceased, then we've gotta do the
Right.
probate. And then we still, after the probate, depending who the personal representative, depending on the language, how it goes.
Yeah.
So, it's such.
And it's easy. The truth is, why people don't do it, they don't want to spend $1,500, right? I mean, you'll buy a $500,000 property, but then $1,500, no, I'm not gonna do that.
It's very easy to do.
Yeah, it's very easy to do. Now, again, probably not something and I personally don't do operating agreements, but a business law attorney can very well, do them for, and again, $1,500, $2,000 or something like that. Yes, it's a lot of money, but when you're talking about even a $200,000 property, why not? It's probably worth it. Okay, so I don't know if that 100% answered your question, but I'm going to switch topics a little bit. We only got a couple more minutes. So I just wanted to give you all an idea of a couple of, part of estate planning obviously is what we've been talking about, how to leave assets, how you want to leave your house, how you want to leave your money, all of that, planning for young children. That's one part of it. The second component is us while we're still alive, right? Like we don't want to just think about, our impending death at some point. We want to make sure that while we're still alive, we're taken care of. So you might be familiar with healthcare directives. So I'm going to list just a couple that I think are important for everybody to have regardless of age. Because you never know. I just got in Brandon got in an accident on Friday. So it's like, wherever you are in Miami, your life is in jeopardy just driving around. That's a crazy story. Road rage, people fighting on the street on US 1. It was crazy. So, whole other story. But anyway, so a couple documents I recommend. Easy one is called a designation of healthcare surrogate. okay, or sometimes called healthcare proxy. And what that document is basically, if I go to the hospital and I'm having surgery or whatever, and the doctor needs to communicate with somebody else to find out what my wishes are, or to find out, what I would want to happen, I need to name that person. Otherwise, the doctor it puts him or her in a difficult position. So a healthcare proxy, healthcare surrogate form, you name your spouse, you name a brother, you name whoever. Maybe probably not an ex-spouse, because he or she would pull the plug on you if you went in for like a headache. But right. So
Pull the plug.
yeah, right. It's a common cold. Let him go. Yeah. So, but that's a very important. Easy form to fill out. That's something you can get online as well.
And who gets that? How do they know, like, if you ended up in the hospital?
Right. So what I generally recommend to my clients is, obviously make sure that the person you've named has a copy of it. If you have a general physician, give him or her a copy of it as well, so that they have it on file. The other one is called a living will. So a living will gets confused a lot of times with the last will and testament, but a living will is a document that says, if the physician determines that the only way I'm gonna be kept alive is on life support, artificial life support, that I'm choosing not to live that way, right? So not everyone wants to have this document, but, if you know right now, and the doctor says you're gonna be in a vegetative state, not coming out of it, you can go ahead and say what your last wishes are. Because the other option is, you've kind of left your spouse or loved ones stuck in a situation. Because you could just have that healthcare directive. So say you name your spouse. I know this is like a super morbid conversation at 10 a.m. But so say I talk about it every day. But, so say you have your spouse named as the healthcare proxy, and you tell your wife, husband, wife, if I'm like that, pull the plug on me. Well, that's fine while you're still alive, but I would imagine that'd be a very difficult situation for your spouse to be in, because you're kind of, holding on to hope or whatever. So a living will is a way to state in advance what your wishes are. Still makes it hard. Probably the last one I would mention is a power of attorney, right? And so this is, again, easy to do, but Clarita and I were talking about this earlier, because I have a case where a client did their own power of attorney, and it was very limiting on what they could do. So now, what they want to do with this property and some other stuff, they're unable to do, because the power of attorney was one of just those form power of attorney. It didn't check the box, didn't have the right initial in the right places. So a power of attorney, they can be very broad, they can be very specific, they can be for one specific task, and they need to be. Anyways, they're probably not something you want to do yourself, but what they allow you to do is sign document on someone's behalf. So let's say you're not sick, but you're just out of the country, and you need somebody to sign documents for you. You can name someone to do that for you. You can allow someone to go access your finances if you're in the hospital and you need someone to go pay your bills or to take money out of the bank or something like that. You can have health-specific things in there as well. So again, durable power of attorney, also useful. Yes, ma'am.
Is it for financial?
It can financial, yeah.
When we use them for real estate closings, they must be specific to the property that we are dealing with, the transaction, the property in question, and also, if there is a lender involved, we must have the lender approve the power of attorney. Because my spouse may be abroad, and yes, we can use now Ron, but the lender has to have the portal and everything else, that they're using now for remote online notaries.
Right.
But the easiest way is to have a power of attorney, right? I'm here, I can sign on behalf of this person, but the lender has to approve it. And also, Justin, just remind them, power of attorneys expire or die.
Right, yeah, so that happens all the time. Someone's parent had passed away, and now they want to sell the property, and so they'll bring us the power of attorney. They'll say, look, I have the power of attorney. But when a person dies, the power of attorney stops. So, important thing to know. I think that's really it. So I know we're running out of time. If you guys have questions, you have my card. It's super easy. Email justin@probatefirm.com or www.probatefirm.com. Obviously, if you need help with probate or the planning side, happy to help. Make sure you all signed in so I can keep in contact with you and give you a link to the video if you want to rewatch. But thank you all.
Thank you.
Thank you.